Artificial intelligence is being sued. AI is going to court. There are cases on each side of the Atlantic that could very well decide the future of AI. There are court cases everywhere. So is this the end of the AI art bonanza? Stable Diffusion was trained on vast amounts of copyrighted work with no consent, no credit, and no compensation. Huge copyright violations. But hang on, haven't we seen this before? We know what's going on here. We have a precedent. Not that kind of precedent, the other kind, legal precedent. A legal precedent is a similar case already decided by the courts. The precedent here is Perfect 10 versus Google in 2005, and that is the story of Norman Zada, the man who sued the internet. It's time to lawyer up. Let's get legal. Norman Zada was a computer science professor. He was a world-class poker and backgammon champion. He was a gambler and a very successful hedge fund manager. He was a geek. He was a nerd. He was rich. But above all, Norman Zada really liked girls. Nerds don't get the girl. Not normally. But Norman was never normal, and nor was his father. Norman's dad was Lotfi Zada, the guy who invented fuzzy logic. By an amazing twist of fate, Norman's dad was the father of artificial intelligence. In Baku, Azerbaijan, there is a statue of him. He was awarded the Benjamin Franklin Medal in America. He was a big deal. Norman had big shoes to fill. In Norman Zada's autobiography, there is a very telling story about how his glamorous and beautiful mother met his serious and studious father. His dad was as nerdy as Norman. In his book, he says, "For all those less than gorgeous guys out there, there is hope. In this story, the nerd snares the babe." In his book, Norman recalls that from a very early age, he was hell-bent on getting girls. By the age of 3, he had a ranking system to list all the girls he liked in order. By 4, he was trying to impress girls by counting to 1,000,000. It didn't work. They weren't impressed. At the age of 9, he says there were 42 girls in his 4th grade, and he was in love with all of them. But he never so much as kissed a girl. At the end of 6th grade, he asked Mary Schnug out on a date. She said no, so he sat at his desk drawing circuit diagrams. A love-lorn nerd. Norman was smart, a maths prodigy. He got his PhD in just 2 years. He went on to become the chairman of the maths department at Columbia University. He taught at Stanford. He worked at IBM and Bell Labs, and he gambled on sports, and he won. He played backgammon and poker, and he kept on winning. Norman was good with money. He set up a hedge fund and started playing the markets with the big boys, and the real money started to roll in. He hung out with movie stars. He was quoted in the papers. He was rich. He was successful. His opinion was sought by presidents. He had a huge mansion in LA. But still, no girls. So he did what any self-respecting, horny, nerdy millionaire would do. He started a girly magazine. The story goes that a friend of his was rejected by Playboy for not having large enough assets. So Norman put his own assets to work and started Perfect 10 magazine, a girly magazine. You know the kind of thing, top shelf, topless women, but tasteful.
Anyway, it's all done in the best possible taste.
Norman's magazine only featured pictures of girls who had not had cosmetic surgery. He set up a magazine in direct competition with Playboy and Penthouse. Look, times have changed. Sure, he was a pornographer, but I really don't think Norman was a sleaze. I genuinely think he just liked and admired and respected women. He thought that Playboy was having a negative impact on women. He had a very modern view of women's rights. He wanted a magazine that didn't exploit women. Perfect 10 was a huge hit. The magazine sold for $7 a copy, and boy did it sell. He had a website. Membership was $22 a month. He sold VHS videos and did TV deals. This was before YouTube. He was way ahead of his time. He promoted female boxing.
This is 100% real. These girls are trained, we're ready to go. I'm pumped up, I'm ready.
This was way before smartphones. He sold tiny thumbnail pictures that would fit on tiny Nokia mobile phone screens. Now that he owned a girly mag, he was surrounded by the most beautiful women in the world. There were even rumours that he was dating Joan Rivers and Lucille Ball. Everything was going great, and then the internet happened. People were setting up websites. They were taking his pictures. Websites were displaying them as thumbnails, links and images. Google posted his pictures in search results. No one was paying Norman. Perfect 10 made money selling those pictures in magazines and on its website, but suddenly people were giving them away. Revenues were declining. It wasn't fair. Norman was furious. He owned the copyright. Norman was rich enough to sue, so he sued the internet, all of it. In 2005, he sued Amazon and Google. In 2006, he sued CC Bill. In 2011, he sued Mega Upload and Giga News and Microsoft. He sued the entire Newsnet network. He sued everyone. Norman Zada sued the internet. By 2015, he'd filed 30 lawsuits, all for copyright infringement. Zada wanted to protect his assets. He owned the copyright to the images, but Google and others were serving them up for free. They were infringing his copyright. They were giving away the pictures of the girls he loved, the girls he'd worked so hard for. They were ruining everything. So, was Norman right? Is it copyright infringement? Well, of course it is. There's no argument there. Norman was right. The law at the time was absolutely on his side. The internet was the Wild West. Websites just nicked images. No one paid for pictures, but everyone made money from Norman's copyrighted work. And Google were doing it on a massive scale. Google copied the whole internet to its servers. Norman Zada's copyrighted images were in Google search results, and they paid him nothing. They infringed his copyright on an industrial scale. At the time, Norman was hailed as a hero fighting to save copyright holders worldwide from massive copyright infringement by cowboys. Movie studios backed him, record companies sang his praises, publishers adored him. Zada sued Google. He sued everyone. He sued the internet. Everyone thought he would win. And at first he did. He won lots and lots of cases. And then Google appealed. What the case boiled down to was an argument about whether Google and the internet were making derivative or transformative works. In US copyright law, that matters. Derivative works are copyright infringements. Transformative works are not. A derivative work is any work based on or derived from one or more already existing works. Translations, adaptations, reproductions are all derivative works. If you sit down and write a new Harry Potter book, that is a derivative work, and you've got to get permission from J.K. Rowling, and she ain't going to say yes. It's her copyright. She controls it. Even if she does give you permission, you gotta pay her. Works are transformative if they alter an original work with new expression, meaning, or message. Or if it adds value to the original work by creating new information, new aesthetics, new insights, or new understandings. Basically, transformative works take something and change it so much it no longer infringes upon the copyright of the original. If it's transformative, it's not a violation of copyright. You can carry on doing it without paying a penny. Look, there are no hard and fast rules here. It's always a question of judgment on a case-by-case basis. But fundamentally, copyright law here and in the USA is about allowing creators to make stuff without being sued all the time. At its heart, the law is trying to encourage creativity, not stifle it. So be creative. It's the law. In the US, if you get sued for copyright infringement, you can use a defence called fair use. It's not a defence in the UK, but under Section 107 of the US Copyright Act, fair use allows people other than the copyright owner to make a certain limited use of copyrighted material without the copyright owner's permission. The concept of fair use is intended to prevent a too rigid application of copyright law. Fair use has to be new, it has to be original, it has to have a new purpose. In Perfect 10 versus Google in 2005, Norman Zada argued his copyright was infringed. Google argued fair use. After years of hearings, in 2007, the Ninth Circuit Court of Appeals ruled almost entirely in favour of Google. The court said the use of images was not a copyright infringement, it was fair use. The court ruled displaying thumbnails was highly transformative. Specifically, the court ruled that Google had transformed the images from a use of entertainment and artistic expression to one of retrieving information. The court said that Google made available to the public a new and highly beneficial function of improving access to information on the internet. They said search engine technology provides an astoundingly valuable public benefit which should not be jeopardized just because it might be used in a way that could affect somebody else's income. Google, on behalf of the whole internet, said it was fair use. The judges of the Ninth Circuit agreed. That didn't stop Zada. Remember, in Norman Zada's mind, he had paid the models, he'd paid the photographers, he had the copyright on the images, he made a good living selling those images. The lawyers had said he would win, industry had backed him, Google took his pictures with no consent, no credit and no compensation. He carried on suing the internet and he carried on losing. Finally, in 2011, he sued Giga News. He lost yet again, but this time it was decisive. Despite Giga News basically stealing Zada's photos, it was Norman Zada and Perfect 10 who were ordered to pay Giga News $6 million in costs and lawyers' fees. It was over. Norman Zada has sued the internet, and the internet had won. In a way, Norman is a legal hero. He lost the case. His magazine, Perfect 10, went out of business. He'd spent around $50 million on losing and losing. But without him, we wouldn't have clarified the law. The internet would be a very different place. These days, Norman Zada is still the same quiet, self-effacing guy he ever was. He posts music on YouTube, he talks finance, and he still plays backgammon. The last chapter of his autobiography is called Using Computers to Improve Our Justice System and Why We Need Age Limits for Judges. He's stoical, not bitter. Which brings us all the way back to today. In California, the owners and operators of Stable Diffusion, Midjourney, DeviantArt and Stability.ai are all being taken to court in a class action lawsuit led by 3 artists, Sarah Anderson, Kelly McKernan, Carla Ortiz, whose art and images were all nabbed off the web just like Norman Zada's images. AI art generators like Stable Diffusion were trained on images scraped from the internet. Basically, they took around 6 billion images off the web and dumped them into the Lion 5B dataset. It's huge and mind-blowing, 240 terabytes of data, way bigger than anything Google had way back in 2005. Stable Diffusion is trained on all those images to generate new images. The images were taken without the consent of the copyright owners. They just took them and stuffed them into the dataset. In California, the class action lawsuit 323CV00201 filed at the California Northern District Court before Judge Joseph C. Sparrow basically says this is copyright infringement on a massive scale. They say Stable Diffusion was trained on vast amounts of copyrighted works with no consent, no credit, and no compensation. Stable Diffusion is being sued for copyright infringement, not for making exact copies, but for making what the lawsuit calls reconstructed copies, a 21st century collaging tool. Basically, virtual thumbnails. They are saying it's derivative, not transformative. Stable Diffusion, Midjourney, DeviantArt and Stability AI are going to say it's fair use. Of course they are. They are making the very same arguments that Norman Zada listened to in court all those years ago. Judge Joseph C. Sparrow will decide the case. This area of law is so new the court could go either way. I can't predict what the court in America will decide. But make no mistake, this is an opening salvo. Win or lose, there will be appeals and many more cases. This could take decades. How do I know? Because we have a precedent. Over in California, I predict with confidence that Midjourney, DeviantArt and Stability AI will argue their use of the images was highly transformative and has a huge public benefit. They will argue fair use. If I was their lawyer, that's what I'd be saying. I'd be talking in court about Norman Zada and Perfect 10, about a brilliant Jewish kid from 850 James Street in Pelham Manor, New York, a nerd who just wanted to be loved. I'm Matt Fresco. Thank you very much for taking this time to watch my little video. And remember, I love you.
Hi, Matt. I'm better at this than you. Let me explain. AI is taking over.